Good morning. I wanted to talk a little bit about non-competes and what are the considerations from the business side or the management side. So, when you have a non-compete, your ultimate goal is to restrict the ability of your employees or independent contractors to leave the business and go to a competitor or set themselves up as your competitor. And you want to protect your clients, you want to protect your revenue, you want to protect your trade secret information. But what is your legitimate business interest? What is trade secret information? So just be aware that there's a couple caveats you need to be aware of and how this takes place and what that looks like. One of the first, and I just want to go through just 4 common mistakes or misconceptions. And this is going to be relevant to both employees and employers because when they're considering how to draft these documents, they need to be specific about what they're trying to protect and what they're trying to accomplish. So, first thing I want to talk about is what is trade secret information? And one thing it's not, and there's case law to substantiate this, is it's not the information personally developed and created by the employee. So if you have an employee who specializes in going into new territory and building up sales, developing relationships with clients, those relationships are not you are not the property of the employee or are not the property a protectable interest of the management or business. So if I am salesman and Susie salesman goes out and goes into a new area or geographic region and builds clients, what is protectable? She's using your systems. She's using your money because you're paying her to do it, and she's utilizing your reputation. So, is the client list and the relationship she develops something that's protectable? And unfortunately, unless you draft your non-compete correctly, it's not. So if you have a business, let's say it's located in Orlando, all right, and you send someone to Tampa to start using your name, your brand, your information, and your money to go build and set up business, and your non-compete says that she can't work within 60 miles of Orlando, all right, and she can't work in the specific field, and she can't use your client list or your trade secret information. Well, you've made this non-compete for Orlando, but she built her business, or your business, in Tampa. So what she's going to do is she's going to claim that everything your quote-unquote legitimate business interest is all A, outside of the geographic region, and B, it's information she built and developed personally. And this is something that's a very fact-intensive inquiry. But there is case law to support the fact that if the client's the one who built it from the ground up, no matter how much you supported them, your system, your kind of business system, your sales pipeline, your client information, all of these things that you gave her to do that would be protected. But that business she built, it's a little debatable. So just be aware that you need to write non-competes with specificity, focused on what your employees are going to be doing. And if what they do changes, update the non-compete because it's relatively inexpensive compared to having somebody go out and build hundreds of thousands of dollars in business and then try and steal it from you. So from the employee side, if you see a non-compete that paints big brushstrokes of what is legitimate business interest, the geographic area is some ridiculous number like the entire state of Florida or the entire Southeast, depending on the business, what we can do before you sign it is we can look and say, this is what they're going to be successful in enforcing. This is what they're going to have to litigate to enforce. And this is what they're going to have to go through. And they're going to have to fight to get enforced. What is confidential information? So we look through here, it's client lists. So I can say, case law says that clients you create are yours. And the business doesn't have a legitimate business interest in that. And I know that's a difficult item to understand from a nuanced perspective, but it's very, very difficult to enforce one of these non-competes. And the best way to do it is to be very specific about what is a legitimate business interest. So if you give one of your clients an account, you better make sure that if their sole job is to work 3 or 4 accounts, write in those accounts. Put them in there in name. If they're focusing on one industry, if they're working specifically with one supplier. Because if this employee is intelligent, and if their next employer is intelligent and willing to fight for them and to steal that business, you need to be protected. You need to understand what you can enforce and what you can't enforce, and what risk is associated with this. Maybe you want to limit the communication of information. Another thing that's very important, that I'll go into a little later in another one, is you want to compartmentalize information. If you're leaving these quote-unquote confidential items lying about, or you email them to your secretary and everybody else, and it's not restricted to people on a need-to-know basis, then an articulate attorney is going to put this up to a question of fact, of whether or not this confidential information even exists and how it would be protected. So you have to be very, very specific. You have to look through these documents. You have to make sure you're protecting your business, because it's cutthroat out there. And the fact of the matter is that you need to protect yourself and your business and your family. So we'll talk a little bit more about that later. And from an employee side, it's the same thing. So if you get into a cutthroat non-compete that makes it impossible for you to work in the industry you've worked in for the past 20 years, you need to protect yourself there as well. So it's a it's not standard. There's nothing standard about the non-compete process. So talk to an attorney before you jump in, and they can help you kind of dissect that process and recommend changes to language, recommend other items that can help you protect yourself, your employability, and your viability as a candidate for your next employer. Because you better believe some employers won't even touch employees with non-competes because they don't want the headache, they don't want the attorney's fees, and they just don't need it. So protect yourself. A lot of attorneys will give a small consultation fee, and you can learn pretty much what you need to kind of move forward or negotiate certain issue points. So contact me if you have any questions. Otherwise, you guys have a great day.